The snow contract for the 2013-2014 season. You'll have in front of you the marked up copy of the potential contract in front of you.
Mr. Chairman, may I speak?
Yes.
I have a concern, unless somebody else saw it, the first I saw this is laying at the board table tonight, and I don't mean to fault or complain about that, but this is 16 pages long. I mean, this is a contract that could be worth $250,000. I've had not an opportunity to take a look at it. Don't want to be argumentative or uncooperative, but if the board is inclined to vote on this tonight, I'm going to have to abstain because I haven't even had an opportunity to look at it.
I don't think we should vote on it tonight. I think we should review it and get some comments together because there's a great deal of changes in here and perhaps some changes that should be made additionally.
Question?
Yes.
Has this been given to our attorney to review?
That's who did the write-up.
Look at it after.
Good.
Right.
Thank you.
Well, Mr. Chairman, I will move to table this matter for reconsideration at the next meeting on October 24th, and I so move.
Is there a second?
I have a second for discussion.
This is for tabling.
Oh, then I will withdraw my second.
Is there a second to table? Joe, do you have a different motion you'd like to offer?
Yes, I would make a motion to table to next Thursday. And call a meeting to meet on this contract on next Thursday. We could also create an agenda for that meeting on Thursday to include the review of the legal opinion on the warrants.
21st.
7 days from today, 17th, correct. It could snow at any time. We don't have a contract now.
I'll second.
Do you have a time for that meeting?
6:30 p.m., just like a normal board meeting.
I'll support the motion.
Yep. All right, Supervisor Bansky moved to have a special meeting on October 17th at 6:30 PM to review the Title IV legal opinion and have the snow contract.
A
Seconded by Fisher.
quick question, Mr. Bansky. Are we going to have Mr. Deneen here for questions?
I will make that request of him.
And is there a requirement then that we also have Attorney DeLamora here?
I don't see that there is that requirement.
Okay.
Might I ask, are you anticipating he's going to be providing a written opinion, and when might we anticipate that?
I would expect that he will put his opinion into written form. I haven't talked with him about the timeliness to deliver, but based on the fact that I don't think this, he said it would take him 5 to 7 hours, there's a whole lot of those hours between now and then. I'll just tell him he'll have to get it done.
All in favor?
Aye.
Aye. Opposed? Motion carries.
Mr. Chairman, I would suggest as a possibility that Mr. Wolf be provided a copy of this document so that he too can offer his comments. As you have seen briefly, there are a number of changes, and they were prompted by the fact that I understood the board to basically be doing away with the prior winter maintenance policies and procedures. There are some housekeeping matters that I felt needed to be salvaged and incorporated in here, and I want to make sure that Mr. Wolf is comfortable with what I have put in there, and so that you have his input on those issues.
Mr. Chairman,
Yes.
if I could just offer a comment, and thank you, Attorney DeLore. I mean, now that's a new revelation to me. Not only did this just get put on in front of us tonight, but the contractor hasn't seen this yet? Well, then we certainly can't act on it tonight.
No, by no means. Make sure that he gets a copy. On to E, update on the status of the town of Waukesha on-site sewage disposal system. Mike?
It has been a long journey to get to this point. A request for sewer connection to the city had been okayed at the City Common Council meeting on 10/1. This is wonderful, and keep in mind that our town hall property does not have to be annexed to the city. The city has a very strict policy on annexations with water for the last 18 years. I report to you some history and background that took place in order for our town to get where we are at this time. The following City of Waukesha departments were involved with our request. Their engineering department, their water utility commission, their city common council, Department of Public Works and Park and Plan, and legal. Some departments meet once a month and some departments more than that. Our request was subject to approval by all of these departments at various stages of the process. During the approval process, our request was sent back to certain departments for review based on a decision of another city department. Having said this, I view this process of the City of Waukesha as being very thorough. Sure, our town's timetable has been affected by this lengthy course of action. Based on these facts, any rational person would understand that I personally did not direct or control the approval procedure. Patience and understanding are virtues that are rarely displayed in newspaper articles. At this time, a few more bits and pieces are needed for our final wrap-up. Contractors will get a complete package, so in return, we receive an accurate proposal. This town board will explore all options and proposals to serve our town's sewage needs. A rational decision will eventually lead to pipes in the ground.
Mr. Chairman?
Yes.
I guess a question for Supervisor Laska. Thank you for your report. Back on the 22nd of August, a month and a half ago, I asked for the opportunity, and I think there was support from the board, to have an opportunity to review the development of the plans and specifications and bidding documents for technical issues, decisions, concerns, and the like. I believe even Supervisor Bansky supported that. I was looking to receive that within 2 weeks thereafter. I've not seen anything. Maybe you could give us an idea of where you're at with the time schedule. I would like to see the preliminary work on that distributed to the board immediately, so we have an opportunity to review and comment on it. And I would like to ask to have sufficient time to review and comment on any of the final documents before the release for bidding. Can you give us an idea of where we're at, time schedule wise, and whether my oft-made request to have an opportunity to do that is something that you're willing to honor and support.
You had several questions there, Brian, and I do not have anything to give you to look at and/or review at this time. Based on having some of your requests, we have been waiting for the city, as I read very clearly, to get to this point and to acquire and/or compose a proposal that you would like to review and all the other things that you had mentioned is something that can't be done at this time. So why poke holes in what's happening?
Well, I'm not poking holes. I guess give me a vision looking forward. If there's nothing that can be reviewed at this point in time, I mean, we spent $4,900. If there's nothing to see for the $4,900 and you haven't seen it, I guess so be it. Going forward, and I'm reaching out to you, embrace me. Do you have a vision of the timing on this? And I'm asking for an opportunity when something is available to be reviewed, to have an opportunity to do that. It's not any more complicated than that.
I was assured by Chris Janelli that the bits and pieces that are needed will come together. To give you an exact timetable, I cannot. Much in the manner, I could not give you a timetable going into this project based on the information that was needed.
Well, I'm not asking for an exact timetable. I guess I would ask if we're going to have a special meeting next Wednesday. Unless someone objects, can we simply put another item on the agenda and basically have you distribute, and I don't know whether it's possible to do it before then, but not later in the meeting, distribute a copy of the work progress to date. And again, I'm not looking for something exacting. All I'm looking for is a commitment to have an opportunity to see that, review that, to put some technical input into it before the thing is put on the street. It's not more complicated than that. So will you embrace allowing that to be put on the agenda for next week and simply have copies of whatever the progress is to date to be made available for us to review? Real simple.
The meeting is next Thursday instead of Wednesday, and
Is it Wednesday or
they're Thursday. And virtually, with communication with our town, Chris Janelli, may very well be able to put something together. Now, keep in mind, because it's on the agenda, and for whatever reason, we're still waiting for things, much like the insurance limits that is still pending and waiting for, and things of that nature, those things will have to wait, and we shall see what we can come up with prior to next Thursday.
I guess I'll just make it real simple. I understand he's left for the evening, you can't speak for him, but will you commit yourself to contacting him tomorrow and simply ask him if he would make that information available? It's no more complicated than that.
Let me make it simple. I'll see what I can do. I can call tomorrow. It's that simple. Now,
Okay.
put it on the agenda if you wish. And I do not intend to be beaten up over this next Thursday because you don't have the distinct answers that you want. This is very time consuming, and by golly, it took this long, mind you, from June 21st to get to this point, and there still are bits and pieces to make this thing work. Going forward, I anticipate less of an issue had we had city requirements in place, city needs, desires, and all that goes into this project in a more timely manner. There would not be such a crunch time or crunch period. So that's all I got to say.
All right, let's move on. F, consideration and possible action to be taken by the town board regarding appointment of representation in the matter of the estate of Junes Grammes Butler Kemper. Motion for determination of a contested claim scheduled for Wednesday, November 13th, 2013 at 1:30 PM in the room C-219 in the Waukesha County Courthouse. Mr. Vansky, you asked for this to be put on. Can I assume you want to hire another attorney?
No, but nice slight.
That's what it says.
Well, it says that we should send somebody to a matter in which we are being called to speak on whether or not our billing was appropriately directed to the petitioner who signed the MOU. Somebody should be attending that meeting, whether that is our town attorney or an alternate individual, I think is a topic that the board should create a policy on.
Now, what would you like to do? What would you like to do?
We're being, if nobody shows up, the town will not get one red penny of the bill that they have been billed in good faith for. Somebody needs to show up. Would you like to show up, Brian?
No.
So
Would
somebody.
you like to show up, Joe?
Somebody needs to go show up on behalf of the town.
I'm not sure whether somebody showing up other than an attorney is appropriate. Maybe someone else can speak to it. I'm not interested. If you'd like to go, be my guest.
Hector, Brian just asked a question, is it appropriate for somebody who sits on the town board to appear in probate court to represent the town's interest in this building? Or is that limited to strictly an attorney that we would engage or send you?
Generally, in civil actions that are beyond small claims matter, entities have to be represented by an attorney. In probate court, however, depending on the county, the judges are more relaxed about allowing authorized representatives to speak on behalf of an organization.
Was that a yes or a no?
I think I've answered that. It's not a yes or no kind of question.
The question was, would it be appropriate for a town board member to go to this hearing outside of legal counsel?
At the risk of repeating myself, I said generally, judges do not allow individuals to appear unless they are an attorney in matters that are above the small claims action. However, this is a probate matter, and perhaps if a layperson appears, the court might accept a representative from this board. I can't guarantee it for you.
What do you want to do, Mr. Bansky?
Well, I think the question is, John, what is it that you want to do?
My opinion has been made very, very clear. Ask Mr. De La Mora to refund the money that the town paid him for an absurd amount of time to research ancient roads. That's what we should have done. But instead of protecting the town and the town taxpayers, you guys want to go hire more attorneys, or I'm not sure what you want to do. What do you want to do? This is your deal, not mine.
I think the record shows that you were part of the board and directed De La Mora Law Firm when Mr. Butler stood here and threatened to sue the town, directed him to do this research. I mean, now you want to absolve yourself of any action that you've taken and that we took. I mean, Mr. Butler stood here and said, I'm gonna sue you, I'll see you in court,
and
Mr.
the direction
Chairman.
went down there. I'm sorry.
Can I speak to that?
Certainly.
I supported that, but in so doing, anticipated that perhaps an hour or two of time would be spent on this. From my perspective, I wouldn't be sitting here having a problem with this if the town would have gotten a bill for $400 or $500, whether we paid it or passed it along to Mr. Butler. We got a bill for between, I believe it's $2,300 and $2,400 to concur, I believe, with Mr. Butler's opinion. I think that's absurd, and I mean, where we're at this point in time, I guess, do what you choose to do. I'm not interested in playing Matlock. I'm not going to court, okay? If you want to do that, be my guest. The town should never have incurred a bill of this nature at any point in time, let alone pass it along to Mr. Butler. If the way forward has to be every time we say, will you please review it, then maybe we need to have an agreement with legal counsel as to how much time they're going to spend.
It might be wise.
Yeah, I think
I'm
so.
not saying that it's not wise to say, as I made the motion earlier, to put a dollar limit on it, to say, hey, here's the number. I think that sets clear expectation. I think that in this case, in particular, Mr. Butler's threat of a lawsuit did not allow for a cursory, let me just flip through the page and kind of get a touchy-feely about it, because had Mr. Gilmore given us a touchy-feely piece of advice that was proven later to be inadequate due to a cursory review, we may have had other arguments and concerns here. So maybe he was, I'm not trying to put words in his mouth, but maybe he was acting in such a way as to do that review thoroughly because Mr. Butler took a very specific stance and very specific action in threatening to sue the town over this ancient road thing. And the resulting action happened as he signed the MOU. He would be responsible for that action. Somebody has to appear on behalf of the town of Waukesha. Whether we decide that that is somebody from the DeMora, whether we decide that that is, we take the risk that a judge in a probate hearing will allow the representative that's appointed from a board position to be there, or somebody wants to suggest a different attorney. I have none that I would suggest. I'm interested to hear what my peers think about that, but somebody's got to go. We cannot choose to send no one.
Mr. Laska?
I would support that, Joe, and obviously we cannot ask Attorney Hector to defend himself, if you will. An issue I have with this, and I should have brought this up earlier, the fact that it will be going to court, we shouldn't even have discussion on this issue. My way of looking at it, as an open meeting, whatever our discussion was can be used against our claim in the court proceedings of November 13th. But that's water over the dam at this point. So virtually I will support sending a representative, and like Attorney Hector indicated, the judge is more receptive to attorneys being present. Correct me if I'm wrong. Is that correct, Attorney Hector? Thank you.
Hector, what kind of hours involved with you walking in to represent us in this probate? Ballpark? We talking about a 5-hour or 2-hour?
Well, anytime you go to court, it's always very dependent on what the calendar is for that day and where the judge is on that matter. Oftentimes, there's a considerable amount of waiting time in probate court. If it goes to a hearing, there would be the need to prepare, and I would think a range of anywhere between 5 and 8 hours would be realistic.
Hector, do we have the ability to request that Mr. Butler participate in a mediation process on this bill?
Mr. Butler has signed a contract as the personal representative of the estate, and it is permissible to attempt to sit down and work out something. Among the various things that would be argued in the court would be that the court does not have jurisdiction over the town, and the court does not have, in a technical sense, competence over this matter, because basically what Mr. Butler did was he entered into a contract, specifically showed up here and threatened to sue the town, exacerbating the need for the town to carefully look at the position that it had taken. Mind you, the position taken by the town prior to Mr. Butler's threat was that in order to approve the CSM, there had to be compliance with a practice that the town typically required in other cases. And this was a recommendation that was made by the planner. Ultimately, after reviewing basically the absence of any clear authority to support Mr. Butler's contention, we recommended to the town, in light of the information provided by the town engineer, that an alternate approach be taken in an effort to diffuse the possibility of litigation. And that was to basically reserve the roadway. If you recall that evening, Mr. Butler indicated that he was very pleased with that approach. The documents were processed, ultimately, I believe, recorded. Now, Mr. Butler, having second thoughts about, I suspect, his own actions in this matter, is attempting to use the court to absolve him of the responsibility that he undertook when he both signed the contract to reimburse the town for whatever needs the town had, and his elevation of the threat to the town that he would sue the town.
Cut to the chase, Joe. What do you want to do?
Guess I'd make a motion to have Jamie list this item on the agenda for next Thursday and have a certified letter sent to Mr. Butler to ask him to come in and meet with the town board to attempt to mediate this bill article in court. That would be my motion.
Is there a second?
I'll second.
Discussion?
Question, go ahead. Please.
Question for Attorney Hector. When or if this thing goes to court, can the town recoup any expenses based on the outcome for our attendance, attorney fees, whatever the case may be?
Unfortunately not. The courts in this state follow what is known as the American rule, which basically states that win or lose, in the absence of a specific statutory provision, each party pays for their own attorney representation.
Question, go ahead. Question, Supervisor Mansky, are you asking for Attorney De La Mora to be present in the room at that time.
I don't think that that's necessary.
Okay.
Anything else? Could you read back the motion, please?
Supervisor Vansky moved to send a certified letter to Mr. Butler to attend a meeting on October 17th at 6:30 PM for mediation.
May I ask you one question, Rod? Do you have a plan B if he declines to attend?
Not at this point. We'd have to go back to, somebody needs to show up at this hearing. Or we have to understand that we're gonna eat the $2,325 or $45 bill that's there, because the judge is gonna say, no one's here, they obviously don't care for the bill, just move, there goes the vote.
All in favor?
Aye.
Opposed? Motion carries. This is primarily an advisory item from Chief Dan, who's unfortunately not here tonight. This is in his 2014 budget. We're gonna have to pay for it upfront. It's about $10,000, and then we get reimbursed half of it. But we have to pay for it upfront. He wanted to make us aware of that. Did I state that all correctly?
Sure.
Okay. On to number 7, accounts payable. Authorization of payment of bills. Is there any that we want to consider separately? Yes.
Backing up on that grant or forest protection grant program,
Yes.
might understand it's gonna cost us $10,725 or $935. And you had mentioned how much do we get back on that?
Half.
Okay. For the benefit of some of us folks that don't understand, is that money well spent?
It is monies that, it is equipment that the fire department deems necessary to have.
And they buy this equipment from part of these funds,
Part of what funds?
what we give them? We're giving, a grant to me means we're receiving money.
There is a grant, and the grant is a 50% grant. We have to pay for it all up front. It's about $10,000 or $10,724.
I
if you
understand
send
that.
it. And then we get half of it back.
Does this happen every year?
I can't answer that question.
Can we opt out?
Sure.
What would be the advantages or disadvantages? For opting out, we save $5,000.
Sure. I guess you can opt out. I guess the disadvantages would be the safety of the firefighters.
Well, we don't know what this
What-
equipment is, let's not accuse Mike of not wanting to keep our
I didn't
firefighters
accuse
safe.
anybody.
You don't-
I didn't accuse anybody of anything, Joe. This is
There's-
equipment that the fire department has deemed was necessary. There's a grant in place for it. You guys, we don't have to approve, there's no action on it required. If you choose not to, if you want to take some action on it.
This is for the 2014 budget that Dan is asking us to insert this, or is he intending on acquiring the debt or the obligation in the year 2013?
I put it in, he had it in the budget layout for you guys in his budget that he had given you guys for the 5,000. I'm not sure if he's spending any monies this year or not. Again, that would come back as a budget amendment anyways, but he's not here to clarify this in specific tonight.
Basically, this needs to be addressed with Dan here.
We're on for next week.
Yeah, Dan, hopefully there's no fire next week Thursday.
Accounts payable, are there any bills that anybody wants to consider individually? The first one is for $119,522.89. Motion to approve the bills?
I move to pay the 119,522.89.
Is there a second?
I'll second that motion.
All in favor?
Aye.
Opposed? Motion carries. The last one is for a manual check for the post office for the coastal meter of $1,500.
Motion to approve.
Second.
All in favor?
Aye.
Motion to adjourn?
Motion.
Second.
All in favor?
Aye.
We are adjourned. Good night, everybody.